Welcome back to another episode here. I am Joshua Vigo-Fas, and this is our YouTube channel. Today, I'm super excited to have our special guest attorney, Mr. Sedric Collins, with us. We're going to be talking about a new assembly bill that just went into effect, I believe 21 days ago as of the shooting of this video, which is AB 2016. So without further ado, I'd like to introduce Attorney Sedric Collins. Mr. Collins, thank you for being here with me today.
Absolutely, Joshua. Thank you so much for having me.
Of course. I'm super excited. I don't think a lot of people know about this new assembly bill. I know us in you obviously yourself in the legal industry, and a lot of attorneys know about what's going on. But I want to talk to you because I want to put content out there about this new bill that just went into effect 21 days ago, which is AB 2016. So I guess if you don't mind, please introduce yourself. Tell us a little bit about yourself, how you started as an attorney, your background.
Absolutely. Well, I'm Sedric Collins, as announced previously. I'm the founding attorney at Legacy One Law Firm. We're based on Los Angeles area, Century City on the west side. And we focus primarily on family legacy planning, wills, trust, estates, and we also do probate, right? So we're very versed and familiar with helping families and individuals kind of navigate the nuances with that.
Right.
So I like to see it as we can help you on kind of maybe both sides of the grave, if you will.
Right.
Those who take that proactive approach and they get that planning in place to help avoid what we're going to talk about today. But then on the other side, well, maybe someone didn't have the opportunity or put off and didn't get a chance to get a plan in place. And now they find themselves, or their family members find themselves having to navigate a probate process, which often involves real estate.
Right. Okay. So walk me through a little bit about AB 2016, because this is a new world for us, right? For the longest time, we've been used to, what's the threshold? 186, 250, if I'm not mistaken.
184,500 for the kind of the minimum, what we call a small estate affidavit process.
Got it.
If you have an estate that's below that threshold, then it's minimal paperwork to be able to kind of marshal those assets and distribute them to the proper heirs.
Right. So, and now before that, anything above 186 was in the probate world.
Exactly.
Right? So now talk me through AB 2016, right? Anything now, what's the threshold?
Well, now, look, the threshold limits are still about the same. It's still at $184,000. But basically what the legislation has done now is kind of expanded that to streamline the process of transferring a decedent's, the person who passed away, their primary residence to the rightful heirs.
Okay.
So I want to be very clear. It does not completely avoid court, but what it is it's a means of help kind of maybe accelerating the process. Because we know probate can be, 6 months, 12 months, 24 months.
Long time.
A long time. So now with the legislation they've done, they've offered some relief for maybe simple estates to where there's maybe a primary residence, someone's passed away, and now maybe they left behind adult children. And now they want to be able to just pass that process along without the full formal probate proceedings.
Got it. So anything below 750.
750. So let me be clear. Yes, $750,000 or below. So if you have properties above that, then it's going to be a full formal probate process. And if it's a rental property, let's say you have a $400,000 condo, if you're so lucky to have one of those these days, right? Well, that is not the primary residence. And so now that would have to go undergo a formal probate proceeding. So it is, it's a rule that's kind of laden with exceptions to qualify for the exemption, but restrictions more so than exceptions, restrictions to obtain this exemption, should I say. So you want to make sure that you have the proper guidance and understand the kind of nuances of this law to make sure that you, first of all, can qualify for this kind of accelerated, streamlined probate process, if you will.
Okay, so we're in LA County. We're one of the probably most expensive cities in all of the nation. What kind of property are we looking at that's even going to, obviously a rental property, but I feel like most properties here are, the median household is like 800,000 now.
Yes.
So it sounds to me like at least most properties are still going to end up going through probate. Am I wrong?
You're right, because one of the things, I don't know what was in the mind of the legislation, but it was basically an exemption that many homes will not qualify for, right? But we still have several families, that individuals that call our office and they have properties at 650, at 700. It's very difficult now in today's market to find a single family home under that, under that 750K. So what we want to be very cautious of is to automatically assume, especially housing values, they don't go down, right? They're typically going to go up.
Right.
So if you're right on that threshold, it's best to seek the advice of a professional such as yourself who can do a proper appraisal to, first of all, help make sure that that property is going to qualify for that exemption, because a property that may be at 700,000 today, in a year may be at 800,000.
Right.
So we don't want to have people maybe delay in their planning while they're alive, thinking that, oh, our house is at 725 or 700 today, we're good to go. And a year from now, they pass away, and now their family's in probate.
Yeah. How long do people have to wait? Like, let's say mom died April 1st. Do they file? What's the process, right? Do they file immediately with the court? Do they have to wait a certain amount of time in order to begin the process?
Yeah, so right now, the statute says that at least 40 days must pass. Okay, so a minimum of 40 days, that's what the statute says, after the date of death of the person, of course, who passed away. And then there's a petition process. So petition means you're basically seeking the court's approval. And so this is where it gets tricky, because we don't want to oversimplify and say, oh, you just have to petition the court. Well, it's still a formal proceeding, to where proper notice must be given to all of the heirs. So not to kind of give any legal advice to anyone, but there's several steps that must be followed, including giving notice. How many of us know how to give proper notice? Right?
Not me.
Maybe there is an appraisal process. Well, how do we even determine that your house is worth $750,000? We don't recommend going on to one of these housing websites just to see what a guesstimation may be, because now you may be subject to other issues if the house doesn't meet that minimum threshold, if you will. So that's the process. We strongly recommend seeking still seeking legal advice on this,
of course, because
you want to know who is a rightful heir. Right? So that's the first threshold. Are you even an heir? Maybe the second threshold is, does the property even meet the requirements, right? Is this the primary residence, or is this a rental
property?
So you may need legal help on determining whether or not this is even qualifies as a primary residence. In some cases, it may be obvious, but what if someone like died and they lived in Florida at the time? And this was their primary residence last year, but now this year it's not. And so another important factor is, do you qualify in terms of date of death, right? Because this law applies to those who died after April 1st, 2025. So we get probate calls from folks who've passed away, or the descendants, 5 years after the person died, 3 years, 2 years. So folks will kick the can even on the probate process. So it's very important to note that the date of death must be on or after April 1st, 2025.
Okay, so you mentioned two things. Number one, you mentioned a petition and what you said. And number two, you mentioned an appraisal. So two-parted question. Number one, a petition, if you're saying 40 days, after the 40 days, are you petitioning the court? And part B of that question is, probate matters in LA County get heard in 30 days, right? In COVID, it was different. You had a 6-month waiting period, right? Everybody was getting pushed. Now it's about 30 to 45 days from the moment you file. Are they getting the same priority? Or do you think they're going to get the same priority as a probate administration? Or do you think it's going to be a longer wait time, like 90 days or 6 months?
Well, that's really, I'm going to give you the lawyer answer. It depends. For one of the things that we have to realize is this is brand new legislation. It's going to take time for the courts to adjust to this process. So we don't know yet, since everything is so new, how the court is going to treat or give priority to certain cases based upon the size of the estate. One thing I will share with you is that right now the courts are backed up, and it's taking several months to get a hearing. You may get that initial probate hearing within 60 months, Rob, it's going to be within 60 days. However, if there's one issue, like for example, we have several families right now that we're representing in probate, one heir who they didn't expect objects.
Right.
What's happening now is the courts are saying, okay, the court has to give this heir or potential heir the right to go through some legal process, the right to have a formal written objection. And so now, for something that we thought would be maybe a slam dunk administration process, it gets kicked out 3-4 months because the court calendar is so backed up.
Right.
So something, even with this, I anticipate this as being one of a potential pitfall, one step being missed in the process, and now the court just pushing you back 3 or 4 months, giving you time to get it. It's not just giving you time to get it correct, because you may be able to fix this problem in a week. However, the court is not going to say, okay, come back next week.
Right.
They can have a court calendar, and on that court calendar, you may be 3 months out before you can. You fixed it a week, and then you can be heard now in 3 months, as an example. That's the court calendaring thing that the average layperson may not be familiar with, how the court calendaring works with these petitions.
Understood. And then you also mentioned an appraisal in the probate process. You know, a lot of us are familiar with the probate referee, right? And that's a lot of questions that I get from clients. They're like, oh, am I going to meet the referee? Are they going to come to the house? How do they, do I have to send a picture of everything? How is that? Is there going to be a referee during this process as well? Because I know there's going to be you mentioned an appraisal. So there's an inventory and appraisal throughout this process. Is that done through a referee? Is that an outside appraiser? How does that process? How will that work?
Well, this is one thing that we have not encountered yet, being that we're brand new. What court staff is going to be assigned to this? Remember, this is going to be more of an affidavit process. But however, you're going to want to seek a professional appraisal done.
Got it.
And so this is where you're going to seek the assistance of someone who is versed, such as yourself in real estate, who has this relationship with these court-approved appraisers that can basically work with you. You don't want to try to undergo this alone by yourself. You want to seek legal counsel, a real estate professional, an attorney, so that way we can communicate with the court now, especially in these early initial stages, to see what the court is going to accept. Right? Because this isn't a formal probate proceeding, but it doesn't mean there's no formal steps that need to be taking place to make sure you're doing it correctly.
Got it.
So yes, you're going to have a professional appraisal. How the court's going to treat this yet, we've yet to see that, seeing that we're only a few weeks into this law.
Right. So there's really no evidence of how this is going to play out. I mean, it's brand new.
It's brand new.
We probably won't even see how this plays out until possibly 2026. Well, I'm assuming.
Well, we're going to see some of the effects, because now obviously we've had folks that have died since April 1st, right?
Right.
But like I say, there's typically where there's a 30-day period after a person has died to lodge a will with the court. Not everybody follows that rule. Some people don't know. Oh, I didn't know I had 30 days. And so now you can get a will submitted even 90 days, even longer, right? Sometimes years later. So it's really, when you're dealing with this process of a new law being enacted, how the treatment of the law is what we call that, that sometimes takes a little bit of time. Right? Because like I say, this is brand new to the courts as well. So how they're going to administer it, many law firms have not seen that yet. In fact, as of this date, we have not received one phone call from a person that's died April 1st. I'm sure there are firms that have, but right now the calls that we've been getting have been people who have died prior to April 1st.
Got it.
Because a lot of times when someone dies, you have to bury that person. You're still kind of getting things together.
Right.
And then there's a time period after that, you've grieved a little bit. Now folks start seeking legal representation.
Right.
And so we're going to start seeing over the next 30 to 60 days, a lot of influx of folks who have passed away on that April 1st mark. And so now we'll be able to see from evidence how the court is treating this new law in terms of from an administrative standpoint.
Got it. Do you think this will open the door for fraud amongst siblings and, maybe you have a kid here, maybe you have a kid in another part, and they try to keep the property. Do you think that's going to happen? It's going to be a lot more of that?
Well, we don't know if there's already cases out there, even some that we've dealt with, that deal with like will fraudulent, you've seen that, right?
In your line of work. And but so in terms of notices, giving, I guess you said you have to give notice, right?
Yeah, exactly.
So are there going to be family members that try to circumvent that to keep a property?
Absolutely, because now what the average lay person is going to think, like, oh, wait a minute, This is a streamlined process. I really
Right.
don't have to go through a formal probate. I can just petition,
Right.
right? So now you may see a more of a DIY approach from some people, thinking that they can go about it on their own. Oh, it's simple. There's no probate. I don't really need any legal counsel. Now maybe here's an heir who might not have qualified.
Right.
Now thinking they may qualify, I can just petition. And but I think that there's going to be more people are going to be more courageous with that now, because now they're going to start hearing. And we want to be clear about that. Oh, maybe you don't need to have an estate plan now. Maybe you don't need to have an attorney or representation. It's simple. You just petition. And so now that can create maybe a false sense of courage for some people to step forward and maybe do things that the traditional probate process would have kind of weeded out a little bit.
Yeah.
So we may see that. So maybe there is an increase in fraud. It's too early to say that, but there's definitely going to be an increase of mistakes, right?
Oh,
Because
sure.
now people stepping forward saying, hey, I can now do this myself, because it's a streamlined process, if you
Yep.
will. And so we're going to see errors all over the place. So I think it's going to take a few years for the court to kind of ferret out some of those initial kind of pitfalls, if you will, for those DIYers, especially
Got
do-it-yourselfs crowd.
Is estate planning still the way to go this year?
Absolutely. It is
Okay.
the way to go every year.
Okay.
And the reason being is because one of the number one concerns I see as a trust and estates attorney, folks don't want to deal with the court.
Yeah.
They don't want their kids and their grandkids to have to petition the court, hire a lawyer, and go through anything dealing with the state. That's one of the number one things we hear is like, hey, I don't want the state involved at all in this.
Yeah.
I want a way that I can pass down my property without the court and government being involved. And an estate plan still is the number one way to do that, because it allows you to set the terms, how and when your property will be passed down. Who do you want to have in charge? And also, something that this new law doesn't speak to is, what if you have minors? What if you have a house that you want to leave to someone and their kids? You own a home when you have a 10-year-old, a 12-year-old.
Yeah.
What if you have a child or someone who has special needs
Yeah.
that you want to benefit from this house?
Right.
This new law is not designed to address those in those special categories. Minors, kids under 18, special needs individuals who may need legal guidance, or they may have to be subjected to the formal probate proceeding now, because nothing can just be streamlined with those special beneficiaries or heirs.
Okay. Let's say somebody goes through this process. They file the affidavit. What is the process? And they go however long it takes, right? How are they then able to, in probate, you get letters of administration, testamentary letters. Bam, you are personal representative of the estate. Bam, you can now sell the property. You can open the bank account, EIN, communicate with creditors. So what will allow families, next of kin, the heir, to now go ahead and sell the property? Is there going to be an order from the court that's going to be issued? You know what I mean? And I'm thinking in terms of title, right? That will be an easy transfer of title for the next person.
That's a great question, Joshua. None of this is going to happen automatically.
Okay.
So there is going to have to be some court approval. It's just more so of a streamlined approval process.
Okay.
In the same way that the small estate affidavits are happening now, it's still paperwork that passes through the estate because we do want to prevent and alleviate fraud or people who don't have a right to certain assets. So yeah, there's still going to be court involvement. There's still going to be paperwork that's going to be issued from the court. There's still going to have to be a clerk's stamp, a judge's approval.
Got it.
So that way, we don't want property to fall into the wrong hands, right? And so that there still has to be some safeguards and things that take place. And that's why the court does have maybe a process that's going to be minimally supervised. So if you can think of the probate process, super formal, very structured.
Yeah.
Now you just have more of an affidavit. Yes, the court's still going to have to put its blessing or its stamp of approval, if you will, but just not the tedious kind of formal process that probate. If you go through probate, you're going to have to go through.
Understood.
So yes, there's still going to be documentation.
Got it.
So
Okay. I think that's all I have. Is there anything that I missed? This is a brand new territory, but I think a lot of folks have questions. Is there anything that I may have missed that you want to cover before we finish?
Well, one of the things that we want to keep in mind that like this laws we kind of alluded to is brand new.
Yeah.
And so with this law, there can be some other concerns that may arrive. And one of the things that we've been speaking about here in the legal community is maybe the rise of potential disputes among siblings. One of the toughest challenges that we face sometimes when we petition the court, sometimes we have several siblings fighting over who's going to be in charge. Right? So that can be sometimes 6 months or a year process of back and forth objections. And this sibling has an attorney over here. This sibling has an attorney. And so the same thing can happen now with this so-called streamlined process. Because now what happens if you have several potential heirs petitioning, meaning asking the court to grant them the right to, to inherit the property?
Right. Because in probate, that they have equal priority, right? The children under the probate code.
Exactly. So now, what about if you have 2 or 3 siblings who are not on the same page?
Right.
What about children from outside relationships and marriages? Right. And so now you have maybe an estranged child or a sibling that you don't even know you have that's now petitioned you. Right. And so now you're going to say, hey, well, that person doesn't have a right. We don't even know who this person is. Lo and behold, this is maybe an estranged child or a child from another relationship that now has equal rights as you. And so one of the things that the probate process allows us to do is to properly vet people out. There's a process involved for a reason. Now, if it's more so, I don't want to say the wild, wild west, but now if folks feel like they can just freely petition now without too much process, that's a potential pitfall of more partitions, more people. What that is, a partition is where folks are kind of disputing ownership of land and wanting to have properties kind of separated out now. So there's a lot of unknowns and uncertainties here. And so the number one piece of advice that I can give here, not legal advice, but practical advice, is to seek legal counsel with this. Because even as practitioners, we're still having to navigate, and we're still having to see how the court is going to treat this law. So it's one thing to have a law. It's another thing to see how the legal system is going to treat it, how they're going to administer, how they're going to handle it. So please do seek the advice of a legal professional within the areas of trust estates and probate, and also with real estate professionals as well, such as yourself, that can help them kind of navigate this process.
Absolutely. Awesome. Well, you're a trust and estate attorney, so you handle estate planning, probate administration, trust administration, and now this AB 2016 that we're going to see how it plays out over the next few months.
Absolutely.
We are going to put your contact information in our channel, but is there another best way for people to reach out to you? Do you prefer email, people to reach out to your office to schedule a consultation? What's the best way to get on your calendar?
That's a great question. Thank you so much for that, Joshua. We have a few different ways. For those people who are tech savvy, they can go right to our website, Legacy One Law. That's the word legacy, law.com. There's a link there where they can schedule a free consultation to speak directly with me. We have a calendar link there. For those of us that don't want to go online, they can contact our office, and we have a team that's there 24 hours a day that can schedule the appointment for them. They can meet directly with me or a member of my team. What we'll do is we'll kind of have a discovery call. Just to kind of figure out what's going on, because one of the things that we'll find is that a lot of folks don't know even when they should file for probate, for the traditional probate process. And so that's a potential area of inquiry as well, is like, who's really on the deed? And so a lot of folks don't know. They think that their parents or grandparents own this house, but then we can do extra inquiry to figure out that their grandparents or parents may not even legally own that property. And so that discovery call helps us kind of go through some of those initial preliminary concerns that can be setbacks to the administration of the estate.
I see that a lot, where they think it's one person on title. You pull the property profile and it's James Smith and Jenny Smith, and James died. And we're like, who's Jenny Smith? Oh, well, she was, my dad's spouse. Is she still alive? Yeah, she's still alive. Where is she?
Yes, exactly.
That situation. So that's always important to make sure, either with a real estate professional or a practitioner like yourself, because we're able to pull that up pretty instantly. Awesome. Well, I'm really thankful that you came to speak with me. I know that there's not a lot of content about this, and I know that this will reach a lot of families as they navigate this process. This is still new. This is 21 days old that this just kicked in. But I'm sure that when people realize that they need to do this, right, if they're under that threshold, I hope that this content is valuable to them. So thank you so much for sitting down with me. Your wealth and your knowledge is wealth. It's very educational to a lot of families out there. So thank you so much.
Absolutely. Thank you so much for having me, Josh.
Of course.
I appreciate it.
All right. Well, that's it. Thank you everyone for watching. Josh V sitting here with Attorney Collins. We'll see you on the next video.